Just to make sure that everybody can maximize their CLE here, I think we'll get started. My name is Elizabeth Anderson. I'm the Executive Director here at ASIL, and welcome to this brown bag discussion about customary international law. I think there are few topics that international lawyers love to haggle about more than customary international law. What is it? How do you make it? Is it binding? Is it, how do you enforce it, and what kinds of institutions? And so we're going to take a crack at least some of those questions here today, taking advantage of the fact that Kurt Bradley is in town. Kurt is Vice President of the Society, member of our journal board, and as well as being, those are most important from my perspective, because many roles. He's also the William Van Alstyne Professor at Duke Law School, and holds a number of other important posts in the field, and his bio is here in front of you. We're going to have, along with Kurt, I should say he's also, you can't do this, he's the author of this recent book, International Law in the U.S. Legal System, and there's a chapter on customary international law that I'm sure will be the focus of some of his remarks today. Kurt and Brad Clark and Carlos Vasquez often exchanged views in these kinds of settings and in writing about customary international law, so we're happy to take advantage of Kurt's being here to bring together Brad Clark from GW, University Law School, and Carlos Vasquez from Georgetown University Law Center. Carlos will be joining us shortly. Brad's resume or bio is also in front of you. He has written broadly on not just foreign relations law and U.S. approaches to international law, but civil procedure, constitutional law, and federal courts, and is published widely on those subjects. And Carlos, who will be joining us shortly, is a professor at Georgetown Law Center. He's also on the American Journal of International Law at Board of Editors, and holds a number of other posts in the CERD Committee at the UN and the Inter-American Juridical Committee in the past. So, without much further introduction of our topic, I think I'll ask Kurt to start off and give us his take on the subject, and then we'll turn to Carlos and Brad.
Thank you, Betsy, and thanks to everybody for coming during the lunch hour. I hope you'll find it's an interesting topic. It's an important topic. Customary international law is coming up a lot in American courts in a variety of cases, including some interesting criminal cases that I'll mention briefly. What I'm not, I think probably none of us are going to focus on, are the many issues about how customary international law forms and how one tries to identify it. There are many of those issues, and I teach them when I teach international law. Everybody agrees that customary international law is based on the widespread and consistent practices of nations, that they follow out of a sense of legal obligation. But after that kind of agreement, there's much debate about exactly how it forms, and particularly what evidence one would try to look for. Just to give you an example, DC Circuit has had to deal with these military commission cases recently, and customary international law is relevant to those prosecutions. And the DC Circuit said, it is often difficult to determine what constitutes customary international law, who defines customary international law, and how firmly established a norm has to be to qualify as a customary international law norm. And that is going to be a set of issues, not ones that we're particularly focused on, I think. Our focus on this panel is about the status of that material, those customary norms, inside the United States, and particularly in U.S. adjudications. The bottom line of and I passed out just a one-page handout, and this is really taken from my chapter 5 of the book I had recently written. I'm just going to quickly go through some of the points on that outline, and I can guarantee the other two speakers have some different views, which will be good to hear them and see how they fit or don't fit with some of the things that I'm about to note. The place I always start, of course, and most people would, was the constitutional text to try to figure out where customary international law belongs. And the text of the Constitution is nice in that it actually has a provision telling us what federal law is. And it has a list. And it actually says, the Constitution, not surprisingly, is our federal law. and the laws of the United States made pursuant to it, like federal statutes, of course, are federal law. And then international law is in the sense of treaties. It only mentions treaties made under the authority of the United States. No mention there, at least, of customary international law. And the founders would have actually called it the law of nations. That was the phrase they would have used when they wrote the Constitution. They knew about the law of nations. They knew a lot more about it than we do, actually. That was the major form of international law. We had almost no treaties at the founding. And the law of nations regulated almost any important international relations subject, like the law of the sea and war and immunity back then. So they knew about it. The only place they ever mention in the Constitution is when they list Congress's powers to regulate commerce and bankruptcy and what have you. They include a power to define and punish offenses against the law of nations. Most obviously to criminalize offenses against the law of nations, as well as piracy. We actually now have a bunch of piracy cases using that power in the government. But that just seems to suggest Congress can codify these norms and make them law. And the question that I think is most interesting, everybody agrees on that, the question most interesting is what happens if Congress has not done that? And my position, as you can tell just from the heading of the outline, is that customary international law, these important norms of international law, do not themselves automatically operate as American federal law that would automatically preempt state law, create federal court jurisdiction, maybe bind the president, and do some other things that federal law can do. Not to say it's unimportant. I'll give you examples in a few minutes why I think it's quite important in the United States, customary international law. It's just not automatically, in some broad-based way, federal law. It's not like treaties. Treaties are, when we ratify them, federal law in certain kinds of ways. So, in addition to the text, which seems to talk about treaties but not custom, the other thing I'd emphasize is we have about 225 years of judicial precedent in the United States right now, since the founding of the Constitution. There is not one decision in the history of the United States that clearly holds that customary international law can preempt state law. There are many decisions holding that about treaties. In fact, the first major treaty case, it's called Ware v. Tilton, was about how treaties clearly can preempt state law. We don't have any cases in 225 years saying about that about custom. And in Ware v. Hilton, two of the justices, without any complaint by anybody else, said, and by the way, that's not true of customary international law, the law of nations. And so the precedent is just very, the sounds of silence get pretty strong after 225 years. You would think you would have had at least one case by now. There are legal process concerns that you don't have with treaties. Because Congress has not formally endorsed customary international law, sometimes the President has not formally endorsed it either. So we don't have any democratic deliberation in any systematic way about its content. It's worked out kind of informally of the 193 nations. The states, like Virginia or my state, North Carolina, are not represented in any body that decides on customary international law in the way that they are, say, for federal statutes or for treaties are really hard to make because each state gets two representatives in the Senate. They can argue about these treaties. They don't get to argue about customary international law. We don't have any of the process protections we have for any other federal law in the United States. And then getting to treaties, it turns out, I said treaties in the Supremacy Clause, they can preempt state law, Ware v. Hilton, all true. Not all treaties can do that, it turns out, and probably many cannot. Many treaties are not self-executing, it turns out. That's kind of a doctrine that got developed after the founding, but it's well established since the 1820s or so. And the recent case of Medellin from a few years ago, whether you like the case or not, a Supreme Court decision says many treaties are not self-executing. It means you can't enforce them as federal law. Those are documents that go through 2/3 of the Senate, presidential ratification. They still don't get to be federal law. And so it seems particularly anomalous to say, but as long as there's custom out there that might be exactly the same as the treaty, it gets to be federal law. It just doesn't make a lot of sense. Now, I should be clear, there are some things that are not treaties and not statutes and not the Constitution that are federal law, which are some judicial doctrines here and there that are allowed to be kind of judicially made federal law. And we call that federal common law, and there are certain examples of that out there. The Supreme Court doesn't particularly like that stuff, at least this current Supreme Court, so it's not really eager to add any new categories of that. The key thing about it, though, is it's supposed to be just gap filling in what they call the interstices of other kinds of federal law. It's supposed to be tied to the policies of the Constitution and existing federal law, not separate. And it's neither of those two requirements, that it's sort of a gap filling interstitial kind of thing in the body of law, and it's supposed to be tied to what the Constitution has decided and what Congress has decided and the President has decided. Neither requirements apply to customary international law. It can develop without either one of those requirements, and doesn't seem to fit when we do allow some of these judicial federal law doctrines to operate. We have another case, some of you may know this case, Brad and I were talking about it before, Sosa against Albert McShane, which is the only Supreme Court case on this thing called the Alien Tort Statute. The Supreme Court's about to give us another one of these decisions, maybe one that'll give a more clarity here. But Sosa, which is a weird case about an abduction of a doctor from Mexico and suing the Mexican kidnapper under the Alien Tort Statute, it's not clear what Sosa holds. It seems to allow some Alien Tort Statute litigation to continue. Everybody agrees on that. But one thing it makes clear, I think, is that it says that the reason these courts can apply some customary norms, and it said only a modest number, etc., is because of the sanction of the Alien Tort Statute. It has a theory that Congress in the Alien Tort Statute was sanctioning certain kinds of uses of customary international law. That theory does not seem to suggest it thought that customary international law was already operating kind of wholesale as federal law. It thought the Alien Tort Statute had to kind of bring it in some modest number of cases. And interestingly, I just found recently, the Ninth Circuit, which tends to love Alien Tort Statute litigation, en banc, just from a couple years ago, said customary international law is not federal law unless it's brought in through something like the Alien Tort Statute, and citing Sosa for that. So agreeing with what many of the things I've written about before. Now, last thing I want to say is to emphasize, some people forget this, just because customary international law doesn't operate automatically like federal law, like some treaties do, doesn't mean it's unimportant. It's hugely important in a lot of cases, and actually I think increasingly important. So some statutes actually incorporate customary international law directly. There's a taking of properties exception in the Immunities Act. The piracy statute is now big again because of all these Somali pirates. It says piracy is defined by the law of nations, by customary international law. The Alien Tort Statute, it may be cut back soon. We'll see what Kiobel has to say, which could be any day now. But it clearly refers to the law of nations and in some sense allows some use of it in litigation. Maybe more importantly, the Supreme Court of the United States has long said that when it interprets federal statutes, just regular ones, like securities law or anything else, the court should try to interpret those statutes to avoid violations of customary international law, like on extraterritoriality. So even though we're not applying it directly as federal law, if it causes this change in the interpretation of the statute, that's quite a significant use. And that's very well established. Almost everybody agrees with it, including, I think, all the justices on the Supreme Court agree with that use of it. There's some recent cases. There's this interesting case in the 11th Circuit. I cited a drug trafficking case that grabbed some Panamanian drug traffickers in Panama. And the only basis for Congress to try to do that, to regulate that, was this power to define and punish offenses against the law of nations. And the 11th Circuit said, you can only punish things that are actually a violation of the law of nations. You just can't make it up. And they decided that drug trafficking was not really a violation of the law of nations. So that was a limit on a significant federal prosecution and on a statute. Military commissions, I mentioned these already, but it turns out that it may be the case that to prosecute these people in Guantanamo, for most of the crimes have to be ones that were already violations of the law of nations, of customary international law. And so the DC Circuit is finding that some things are not, like material support for terrorism. It just doesn't violate the law of nations. So that's a huge decision in the war on terror. And this is the last point I'll make, because it's sort of the most complicated one. There are some times where these judicially developed rules of federal law are allowed, even if the Supreme Court doesn't particularly like them anymore. They still allow them sometimes. I can imagine some doctrines concerning foreign affairs that are informed in part by customary international law, and in part by the policies of maybe the executive branch, and in part by what Congress has already enacted in related areas. It would be a hybrid. It would be some kind of combination of domestic and international considerations. A great example of that happening right now in the courts is the issue of what immunity do foreign officials get, say former heads of state or lower level officials who are being sued in civil litigation in the United States. There's no statute on that. There's no treaty on it. So what are courts going to do? There's been a Supreme Court activity saying basically you've got to apply some common law on this, a case called Samantar a couple years ago. And they have started trying to do this. And what have they done? None of them have said, customary international law, we just look to it and apply it wholesale as federal law. Not a single decision. We have now about 10 decisions. Nor has the State Department, which cares a lot about international law, obviously, never has it said you should just look to customary international law and apply it as federal law. Not a single State Department. I was talking to the State Department about this yesterday. Rather, the courts and the government have suggested it's some kind of combination. We've got statutes like the Foreign Sovereign Immunities Act that has certain kind of policies in place. Statutes like the Torture Victim Protection Act, which has certain kind of countervailing policies. We have executive branch policies and positions over a long period of time, actually, on immunity. and we have international law considerations. And the courts look like they're combining those into some kind of domestic common law rule to have some kind of a sensible immunity regime, but not because they just automatically think that customary international law on this is federal law. So it can matter, but in ways that are combined with a lot of domestic considerations. And I think that's the way we're likely to see it play a role in the courts. So I'll stop there.
Okay, wonderful. Thank you, Kurt. That's a good start. Brad, let's hear your take.
Great, yeah. So I come at this from the domestic side of constitutional law, constitutional structure, federal court jurisdiction. That's where I kind of came from. But then I got interested, when I was writing about federal common law years ago, I got interested in this enclave of federal common law and foreign relations that some people talk about. And then, of course, the debate over the status of customary international law that Kurt has engaged in so terrifically over the years. And so I want to start by emphasizing something that Kurt touched upon, which is the Supremacy Clause and the original design of the Constitution. So, as Kurt mentioned, if you look at the Supremacy Clause...
Excellent. Our third speaker. Carlos, they assured me that you would know everything they were going to say, so it was fair to start.
Actually, Kurt gave a handout of what he said, and I'm just starting, so, and you know what I'm going to say anyway. So, I mean, to focus just for a minute on the Supremacy Clause of the Constitution, as Kurt mentioned, that really only recognizes three sources of federal law supreme in the United States, especially over contrary state law, right? This Constitution, laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under their authority. And that's significant, I think, for several reasons. First of all, because if you go back to the convention when they were drafting the Constitution, there's a relationship between the fight, one of the central fights of the convention, which was the representation of the states in the Senate, and the lawmaking procedures and the Supremacy Clause. So it was a huge fight at the convention between the large states and the small states over the representation in the Senate. The large states, not surprisingly, wanted to have proportional representation for the states in the Senate as they had in the House of Representatives. The small states, not surprisingly, wanted equal suffrage in the Senate. And the convention was essentially deadlocked over this question, and they actually took a break and they appointed a grand committee and they went and studied it. They came back with a compromise, which was really not much of a compromise. The compromise was the small states would get equal suffrage in the Senate with the large states, and the House of Representatives would get to initiate bills for raising revenue. That was the deal. And then, of course, Madison and the other people at the convention said that deal is ridiculous, because, as you know how it's played out, the House can amend the Senate can amend the bills, as in other cases, and they don't even follow it, frankly. They just lie, essentially. They just originate in the Senate and then they just say it originated in the House. But so it wasn't much of a compromise. But the equal suffrage of the states in the Senate was significant. And then around the same time, they were drafting all the lawmaking procedures for how you adopt the Constitution, how you adopt laws under Article 1, Section 7, how you adopt treaties under Article 2. And one of the things I would emphasize is that all of the procedures that correspond to the three categories in the Supremacy Clause, all of the procedures involve the Senate, or in the case of constitutional adoption or amendments, the states themselves. That's kind of significant if you think about it. The Senate, in every constitutional amendment that's ever been proposed, has been proposed in part by the Senate, by 2/3 with the House. Every bill that has ever been passed into law has been approved by the Senate. Every treaty that's ever been made has been adopted by 2/3 of the Senate. That's unique. The Senate's in all three procedures. None of the House is not in all three. The President's not in all three. The states are not in all three. The Senate, which was seen as the repository of state authority or state representation, both because of the equal suffrage and because of the the way in which senators were initially appointed by state legislatures was seen as the representative of the states. Well, why is that important? Because in the Supremacy Clause, we're talking about what law counts as supreme over state law. So the states said, okay, we'll put the Senate in every procedure, we'll have a potential veto through the Senate, right? If the Senate doesn't sign off, there's not going to be any supreme law to land to the contrary over state law, right? So that to me, I think, is significant. So when you think about status of other law outside the Supremacy Clause in the U.S. legal system, I think you really have to start with the Supremacy Clause and all that it entails. And we sometimes forget, I mean, that debate over the suffrage in the Senate was hugely important. We've all forgotten it now because nobody cares about small states versus large states anymore. But it's there, right? It was built into the system. And remember, by the way, that the only provision of the Constitution that cannot be amended by Article 5 is the equal suffrage of the states and the Senate. That's exempt from Article 5 in the normal procedure. So, well, what does that mean? I think, that means, I think, that Kurt's position, I would generally agree with, that customary international law cannot just be counted as federal law by some kind of judicial incorporation. First of all, judges, federal judges, or even state judges, they're not, they don't comply with the lawmaking procedures in the Constitution. The Senate's not involved. In fact, federal courts are designed to be immune from the political and procedural safeguards of federalism, right? They have life, tenure, and salary protection. They're not politically accountable, as he mentioned. So to have Article 3 courts use an Article 3 judicial power to incorporate this law and make it supreme is problematic from a constitutional structure and history standpoint. But that's not to say that some aspects of customary international law may not come in to the U.S. constitutional system. So I've been writing with a co-author, A.J. Belia from Notre Dame Law School, and we wrote an article last summer in the Virginia Law Review. I can give you the site if you want. 98 Virginia Law Review, 729, called The Law of Nations as Constitutional Law. And one of the things we tried to do was to suggest that there may be some provisions of the Constitution, really in Article 1 and perhaps Article 2, to move away from Article 3, that either incorporate in some way the law of nations or have to be understood in light of the law of nations, or their exercise might be made effective by reference to the law of nations. So you can imagine, in the Constitution, there are a lot of terms of art, right? There are a lot of common law terms, like trial by jury, or even courts of law and equity, etc. I mean, there's lots of common law terms. There are also some terms from the law of nations. There's the power to declare war. There's the idea of making treaties. There's sending and receiving ambassadors. They don't define ambassadors. They don't define war. There's letters of marque and reprisal, rules concerning captures. And as Kurt said, there's the power to define and punish offenses. But these other things are references to concepts from the law of nations. And so what we said in this article was that perhaps through the exercise of those powers, or even the assignment of those powers, some traditional aspects of the law of nations might be seen as part of the constitutional design. So for example, when the president and perhaps the Senate or the Congress recognizes a foreign nation or a foreign government through the exchange of ambassadors, that means something, right? It meant something under the law of nations when you send and receive ambassadors. And it's not spelled out in the Constitution, but you look to the law of nations background and you get information, right, about what that traditionally meant. And one of the, some of the things that it meant was that each nation would recognize the other nation's sovereign authorities under the law of nations at the time. They would have the right to territorial sovereignty. They would have the right to neutral use of the high seas. They would have the right to send ambassadors with immunity, etc. Right? So there were certain things that countries did, and by recognizing each other, they were saying to each other, "You get this package of rights." Now they could violate those rights, and they might give each other cause for war, or they might have a problem, but it was sort of a shorthand way of saying, we're going to get along and we're going to follow these rules. So, what does that mean? Well, it might mean that, take, I don't want to get too long on this, but take Sabatino, for example, the post-Erie decision on the active state doctrine, which sort of says it applies as a matter of federal law, and it preempts state law even. The Supreme Court, several places where it formulated the doctrine, said this applies to recognized foreign sovereigns, right? And they don't really, explain it too much, but if you think about it, it kind of makes sense. I mean, the courts would kind of be getting out in front of themselves if they applied it to unrecognized foreign sovereigns. They take their lead from the political branches, and by recognizing the foreign sovereign, at least one of the traditional rights of foreign sovereignty was territorial sovereignty. And so even if in 1964 territorial sovereignty is starting to break down, as the court acknowledged, they thought the safer course, right, was to accord, from a judicial perspective, the traditional territorial sovereignty and wait for the political branches to abrogate it. And in fact, they say that at one point in the opinion, right? They say that because notions of territorial sovereignty are so deep-seated, any departure from that might give offense to the foreign sovereign. And they basically say that's for the executive branch or the Congress to offend foreign sovereigns, not the courts. That's their job. Well, all right, and so just to kind of wind up with the head of state immunity that Kurt mentioned at the end, and that's another area where it's possible to think that the court could view that, or some form of it, as an incident of recognition, or some other aspect of constitutional powers of Article 1 or Article 2. Without saying it's a federal common law, kind of Article 3 power, that the courts are making it up. And we were discussing right before the panel, in Samantar, the Supreme Court, they didn't use the phrase federal common law. They said, there might be common law immunity, which was kind of an odd thing to see in a Supreme Court opinion in 2010, since a post-Erie world, but we were speculating that perhaps that's just because the justices don't have an agreement or a full theory yet about how to treat this, and they're skeptical, as Kurt said, of federal common law. Yet at the same time, I think they're sympathetic to the foreign relations implications of not recognizing some head of state immunity.
Okay, great. Thank you very much, Brad. So, coming from different angles, but two votes, I think, for a rather grudging approach to customary international law. Carlos.
I thought it was expansive.
Well, let's hear from Carlos, and then we can decide.
So what are the ground rules? How much time do you?
But I want to leave time for discussion, so if, 10 minutes or so, 7,
Okay.
10 minutes. Veronica, will you make sure that our YouTube audience can see Carlos in that video camera? It looks like it's looking.
Sure.
I don't know.
I'm gonna try to delicately do this.
Can you
Yep,
see
no,
Carlos?
he's in there.
Okay, excellent.
Well, thank you. First of all, I want to apologize for being late. I had a class that ended at noon, and I didn't account for the time necessary to actually get from my class to get here when I agreed to participate in this panel. But I want to thank Kurt for this outline, because I think I'm just going to structure my comments as a response to each of these points. And preliminarily, I think I will claim Brad as somewhat of supporting my position. At least I think that his position in the Virginia piece and in an earlier piece called published in the Columbia Law Review tends to support what I call the traditional or modern position on the status of customary international law, and that is that it's federal law. I mean, this is the position taken by the third restatement of foreign relations law. I think it was clearly the prevailing view when I went to law school. Although I did take the course from the reporter of the restatement. But I think, nevertheless, it's fair to say that was the prevailing view. In fact, I think Kurt's article with Jack Goldsmith disputes describes it that way as the position that prevailed, at least at that time, that they were arguing against. So let me, in defending the modern position, and I have a fairly lengthy article that I wrote defending the modern position, and I have some extra copies here if anyone is interested. Let me address each of the points in Kurt's outline. On the point of view, on the question of constitutional text, it is clear that customary international law is not included in the Supremacy Clause. And so that may suggest that it's not one of the categories of federal law, and Brad just went through that argument. On the other hand, the Constitution is, and this is the respect in which I take Brad's writing as supporting my position, the Constitution does include the Supremacy Clause does include the Constitution as among the categories of federal law. The Constitution itself embraces certain principles of separation of powers, among which are assigning most powers over foreign relations to the federal government, including the war power. And so Brad's article, which I think particularly the Columbia one makes this point very forcefully. The Constitution assigns the war power to the federal government, for example, and so there were cases that indicated early on that state conduct, that state action that violated at least a subset of customary international law could run afoul of the Constitution's assignment of the federal war power to Congress, to the federal government. And more broadly, I think Brad's article notes that the war power is not the only relevant constitutional provision, and that in general, and here I'm supplementing your argument, perhaps going beyond where you'd be comfortable going, I think. But in general, I think the Constitution's separation of powers provisions assign the foreign relations power to the federal government, and an argument could be made that state violations of customary international law are preempted because they unduly interfere with the federal government's conduct of that power. So the constitutional text, I think the absence of customary international law in the Supremacy Clause may cut against the modern position, but it's, I don't regard it as conclusive. Brad also makes a point in his Columbia article that at least in the early days of the nation, before Hudson and Goodwin, the common law itself, there was a position that was shared by many observers that the common law itself was federal. That position ultimately was rejected by the Supreme Court, but as a matter of original intent, that position was out there and held by a not insignificant portion of the observers at the time. The lack of precedent, I'm sorry, I wasn't here to hear this part of Kurt's presentation, but I'm wondering how this was determined, because do you exclude foreign sovereign immunity cases before the FSIA as not being situations where customary international law was applied as federal law?
I'm just saying can't preempt state law. That's what the sentence is.
Well, okay, so then it's the interpretation of preemption, but I would say if a state has a cause of action and customary international law precludes it from going forward, that could be viewed as a preemption of state law in a relevant sense. So I wouldn't exclude those cases. And at the same time, I also would note that I haven't found cases actually approving of state violations of customary international law. So I think the lack of precedent is on both sides. And in fact, many of the pre-Erie cases that are sometimes cited as supporting the revisionist position state clearly that states are not allowed, that states are bound by customary international law. I think Kerr Frisbee is one. So there are a number of cases which I cited here, which, while containing some language that might support the revisionist position, at the same time note that states are bound by customary international law. So sometimes they say, well, we can't review them, we the Supreme Court can't review them, but the states are still bound. So there's at least a lot of dictum. Legal process concerns. I mean, it's true that customary international law is not approved by the elected representatives of the United States, but that's true of other forms of federal common law that are that exist and are recognized, and the constitutional provisions also don't satisfy this requirement, and a lot of the case for treating customary international law as federal law is based on a structural argument, structural constitutional argument along the lines of what Brad has developed. Treaty anomaly. Well, this could get us into another completely separate debate about Medellin, so I will restrain myself. It is true that if you interpret Medellin very broadly, then its whole thing is inconsistent with the idea that customary international law can be self-executing federal law. But I view Medellin as a confused and confusing decision that could be interpreted in a number of different ways, and I favor an interpretation that would not be inconsistent with treating customary international law as federal law. In my writing on treaties, I've noted that treaties can be non-self-executing for a number of different reasons, and I think customary international law similarly can be non-self-executing for those reasons. For example, I view some of the treaty cases as recognizing that courts cannot enforce treaties where the obligation is one that is vague and leaves a lot to discretion and discretion of a type that it's more appropriate for the executive to exercise. And I think that would be true of customary international law provisions if they fell in that category. This, in fact, would yield a test not unlike the Sosa test that the court has adopted for determining which norms of customary international law can be enforced through the Alien Tort Statute. And so I'll defer to later in my comments the discussion of Sosa. The nature of posterior federal common law. Posterior federal common law is interstitial, tied to constitutional and statutory policies. I guess I would agree that customary international law differs from posterior federal common law, but I don't think that that undermines its status as federal law. I think norms can have the status of federal law for different reasons, and I think the reasons that Brad has defended in his Columbia piece, the separation of powers reasons, are a basis for treating customary international law as federal law that don't require it to customary international law to be similar to other forms of federal common law. I mean, there could be a number of different ways in which norms can have federal common law status. I think the reasons for treating customary international law as federal common law are very different from the reasons that justify treating other norms of federal common law as federal law. And then finally, Sosa. Sosa has been described as a Rorschach test. Everyone sees in it what they want to see, and that was Ernie Young's phrase, but I think there's a lot to that. Nevertheless, I will say that I view Sosa as supporting the modern position as opposed to contradicting it. The argument that views Sosa as inconsistent with the modern position, I think, is based on the idea that in Sosa, only a very small category of norms of customary international law were held to be enforceable through the Alien Tort Statute. And if so, that's inconsistent with the modern position, which treats all customary international law as federal law. I don't think that SOSA is inconsistent with the modern position that all international law is federal law, because the issue in SOSA, as I see it, was not whether customary international law was federal, but whether there was a cause of action, a private cause of action for violation of those norms. And it's important here to note that customary international law itself does not create a private civil remedy against individual torturers or, for that matter, corporations. Customary international law has to be supplemented with domestic law in order to find a remedy. And so even in the Philartiga case, the remedy did not come from customary international law itself. It came from, as Sosa put it, a federal common law. The federal common law, the court in Sosa recognized a federal common law cause of action for violation of some norms of customary international law. Admittedly, not all. But again, I don't view that as inconsistent with the position that all customary international law is federal law. After all, there are statutes for which there is no private cause of action for damages. There's no disagreement that the federal statute is federal law, despite the fact that in some cases they might not have any private cause of action attached to them. So for the same reason, the fact that only a limited category of customary international law norms supports a federal common law cause of action for damages does not contradict the view that all customary international law is federal law. Customary international law rarely provides a private remedy for private parties. For this reason, the modern position is most directly implicated in cases where customary international law is invoked as a defense, and that hence we get the sovereign immunity cases, where that is a situation where federal customary international law as federal law is applied directly, where you're talking about the existence of a private remedy against a private individual. International law necessarily has to be supplemented by federal law, and my reading of the Sosa case is that they were limiting the number of norms of customary international law that could support a private cause of action, but not questioning the status of customary international law itself as federal in the first place. So, and I would say, I've argued that Sosa actually, even though I agree that Sosa doesn't resolve this issue definitively, I read Sosa as supporting the modern position more than it detracts from it. Why do I say that? Well, if you look at the private cause of action cases, the cases about implication of private causes of action under statutes, it's very hard. It's almost impossible to infer a private cause of action for violation of federal statutes, and of course federal statutes are indisputably federal law. Here the court found it reasonable to infer a private cause of action for violation of norms of customary international law. And it referred to this private cause of action as a federal cause of action. And so I think it took a more receptive approach to implying causes of action under customary international law than it takes for implying them under federal statutes. And that to me suggests that it acknowledges or recognizes the structural reasons why this issue must be a federal one. I mean, it doesn't seem to have entertained the possibility that the private cause of action for violation of customary international law is a state cause of action. It concluded that it was a federal cause of action, and I think that is telling. So let me just end by giving a thumbnail version of the affirmative argument, because I've been very defensive in my remarks so far. I think the affirmative case for treating customary international law as a federal law has a number of components to it, but first there's a very clear structural reason to treat customary international law as federal law, and to conclude that the federal law preempts state violations of customary international law. Why is that? Well, a violation of customary international law implicates the nation as a whole. The violation of customary international law by a state imposes costs on the nation as a whole. any retaliation will affect the nation as a whole, or can affect the nation as a whole, or can target other states than the one that caused the violation. Yet the benefit of the violation is enjoyed only by that state. So I think it's a very clear structural argument against treating customary international law as a matter of compliance with customary international law as a matter that's completely up to the states. I think that's a strong structural reason for treating it as federal, at least in the sense of being preemptive of state law. And then on the Erie question, I think that the gist of the contrary view, the view that customary international law is not federal, is based on essentially a strong reading of Erie. The argument is before Erie, customary international law was general law. It was not regarded as federal law, even though there were a lot of cases saying international law is part of our law. The reference in those cases was to general law, not to federal law. I question that in part by referring to some of the scholarship that Brad has put forward, where there were some cases indicating that for separation of powers reasons, states were preempted from violating at least some norms of customary international law. But leaving that point aside, I think even if one accepts that pre-Erie, customary international law was general law and not federal law, I think post-Erie we have to make a decision. Should we treat it as state law or federal law? Post-Erie, the concept of general law no longer exists. So post-Erie, customary international law cannot continue to have the same status it had before. We can move in one direction or the other, and I don't think pre-Erie practice necessarily determines that choice, or the pre-Erie practice doesn't require a particular decision on that point. And I think for a number of reasons it makes sense to treat it as federal law, among them the structural reasons that I alluded to. Continuity with the past also, I think, tends more to support the modern position that it's federal law than its opposite. Admittedly, pre-Erie practice, if we treat post-Erie, if post-Erie we treat customary international law as federal law, it will differ to some extent from how it was treated before Erie, but the same is true as if we treat it as state law. Pre-Erie, it was neither of those two. It had some elements of both. But in my view, it had more in common with the modern position than with the revisionist position that we treat it as not federal law. What are those elements? Well, you did have the dictum saying that even if it was not reviewable in the courts, that states were bound by such a law. You also had the fact that the Constitution provides federal jurisdiction for most of these cases. It's not that all of these cases were caught by the jurisdictional provisions, but the Constitution does reveal an intent that these cases mostly be in federal court, and the statutes that implemented Article 3 did provide for jurisdiction in most of these cases. So that means that the courts that would be deciding this issue pre-Erie would overwhelmingly be federal courts. And pre-Erie, federal courts interpreting the general law did not consider themselves bound by state law. They interpreted the general law using their own best lights, and did not regard themselves as bound by state law decisions on what the concept of general law was. And so the upshot is that these were pre-Erie. You had the federal courts interpreting this law in a way, or using their own best lights without being bound by state law. And I think that and in addition to that, you had a lot of dictum saying that states were bound by customary international law. So I think that that's closer to the modern position than the revisionist view is. And if one all of a sudden adopts the revisionist position, I think you would have a lot more violations of international law. I mean, in a world where customary international law was thought of as general law, and everybody, most courts viewed their role as enforcing that general law and complying with that general law. Even if it technically wasn't considered federal law, you have a situation in which there would be relatively few violations of customary international law, whereas outright recognition that it's not federal law and it is state law, could be expected to yield a far greater number of violations of customary international law, and we don't have to speculate on how states would treat customary international law. We have some states now enacting statutes saying that their courts shall not apply customary international law, and under the revisionist position, that's permissible. States can instruct their courts to ignore customary international law. Presumably, they can instruct their courts to adopt the interpretation of their law that most violates customary international law. And if they do that, then the federal courts must follow their interpretation. So we have a very different situation. It's not a situation where both federal and state courts saw it as their role to enforce or interpret and apply customary international law as general law. We would have come from that situation to a situation where both federal and state courts have to follow state law on whether customary international law gets applied at all. And in a state that has specifically said that their courts should not apply it, the federal courts have to follow suit. So I think I've probably taken way more than 10 minutes, so I'll stop there and look forward to this discussion.
Okay, I suspect that Kurt may want to respond, but before I give him an opportunity to do that, maybe see if there are questions. And we can pool a few questions for the panel and then have them all respond. Okay?
My name's Pierce. I'm an LLM student at Georgetown right now. I have a question for Professor Vasquez. I'm fascinated by the idea, the structural argument that you gave as a reason why customary international law should be considered part of federal law. Now, is there any support for that argument in the Constitution? Because if not, then it should be treated, I think it should be treated like a political decision. It should be not a judicial decision, and yeah, so that's basically it.
Well, the support in the Constitution would be the structural arguments, the allocation of the war powers and other foreign relations powers to the federal government. And so the support would be indirect along the lines of what Brad has written. In conjunction with the jurisdictional provisions that provide that most of these cases will be litigated in the federal courts to begin with. And so if you're looking for textual support, that's the best I can do. But I think it's strong enough. And from a non-textual perspective, there is the idea that Brad has written about, that at the beginning it was not even clear what status the general common law had. There was a school of thought that all the common law was federal. And so in terms of so I think that the structural argument can inform the interpretation of those constitutional provisions. And I should add that another aspect of the structural argument, which I think will be very applicable to the current situation, is, as Brad has argued in other writing as well, the Constitution made it difficult to pass federal laws. It imposed obstacles to the enactment of federal law, which makes it difficult to pass federal laws. And so if you read the Federalist Papers and a lot of originalist material about the importance of complying with international law in light of the difficulty, the obstacles that the founders imposed for making federal law, it seems hard to conclude that the founders thought that in order to comply with customary international law and in order to prevent states' violation of customary international law, you had to overcome these very significant obstacles that they put in place for passing the law. And I indicated that observation is well applicable to today's world, where it's almost impossible to pass a law.
Yep.
Hi, I'm Dick Jackson from the U.S. Army. This question's for all three speakers. What's your view of the D.C. Circuit's opinion, I think in Bahani, about well, either their en banc decision or the circuit, the original circuit decision, about the implications of customary international law, and particularly the law of war, to interpretation of the AUMF in habeas litigation?
Good question. Let me answer that briefly because we haven't mentioned that at all. They cite a lot of articles in both the majority opinion and Stephen Williams' dissent in that, his concurrence in that case. The big article he cites is an article I wrote with Jack Goldsmith about the AUMF, and our argument was that a key component of interpreting the AUMF should be the general principles of the international laws of war, and that was his position. It was not the position of Judge Janice Rogers Brown and Kavanaugh, but then, as you know, the en banc majority said that was all dicta about the lack of international law material, so it's unsettled in the D.C. Circuit. My position on that, and this is, I want to go back to something Betsy said, because it sounded at first like maybe Brad and I were kind of negative about some kind of received wisdom, and that sounds like we're grudging in the way that, my position is about where the median judge is. Williams is a Republican judge, but he's very moderate compared to some of the other judges in D.C. My position is around the kind of moderate Democrat judge on customary international law. I teach a lot of judges at a lot of seminars. I have a sense of kind of where they come up. I'm not nearly grudging in, Judge Brown or Kavanaugh, these people who are very resistant to customary international law, not at all. And interesting, Carlos is never able to point out like big decisions we have that would just come out differently if you agree with the things I've said. They would come out exactly the same because courts are only doing the things I have under number 7, including, I could add that your example about the AUMF. Hamdi, the famous Hamdi case in the Supreme Court, does exactly, I think, what Jack and I argued in that Harvard paper, which is to look to the AUMF against the backdrop of international principles, as well as U.S. historical practice, as well as some other things, to try to figure out what Congress probably intended to give the president. And if it can inform how much power Bush or Obama has in the war on terror, we argued can logically impose some kinds of limitations. That was our argument. That's what Stephen Williams agreed with. That's an important role for customary international law, and it's even kind of a slightly lefty, progressive kind of role. But 7 is where the action is in the courts, and none of it turns on the modern position. So, I like academic debate. I'm an academic. It becomes a very academic debate when nothing changes. The only thing Brad and I were talking about, what changes? Before Roe against Simmons, which is the juvenile death penalty Supreme Court case, a lot of people argue that customary international law prohibited the juvenile execution of people who committed their murders when they were under 18. That position, if you buy the modern position, then the federal court should have been striking down. There were about a dozen states that had juvenile death penalties. They should have been invalidating all of those automatically. Not a single federal court was willing to do that. The Supreme Court finally found that it violated the 8th Amendment. But under Carlos' position, this federal court should have been invalidating, but they didn't. But that's like the only example I can come up with, and it's now moved since 2005. So not much is turning on that debate. I hate to say it because I've written way too many articles on the darn thing. What matters is under 7, and things like the define and punish clause, and what Brad mentioned was really important. Everybody wants to claim Brad, which is great for Brad. The head of state immunity is a great example, which is the recognition power of the president, which is kind of implied, of presidential power, may well entail some ability to confer head of state immunity or deny head of state immunity for Noriega, for example. I've always said that's right. The federal courts basically are in agreement with that. And that would come out of some kind of a lawmaking authority of the executive as part of the ambassador clauses and the like. That's a perfectly logical argument. It's probably even right. But you don't need the modern position for any of that. That's all under number 7 on my outline. It's not grudging. It's actually a lot. And it's the most the federal courts, I think, will ever do. They're not going to buy into striking down the juvenile death penalty just based on a direct application of customary international law. It never happened. There was like a dozen cases on that, and every single court rejected it until the Supreme Court took the 8th Amendment issue. And so I just don't see the courts doing more than what we're talking about, but it's quite a bit, actually, I think.
Yeah, I would generally agree with what Kurt just said in the sense that I think it is quite important when courts use customary international law as a background context for interpreting a federal statute, for example, as in the D.C. Circuit case, or even the Constitution. And I really think, today, we didn't talk about this much in the earlier remarks, but, today, sophisticated textualists will say, and most judges are kind of start by being textualists today. I mean, they're really much more focused on the text than in past eras. But I mean, today a sophisticated textualist will say, look, you can't just take the text in the abstract, right? You have to understand the text in context. And part of the context for a lot of these texts is the background law of nations or customary international law. It's hugely important. It provides a lot of meaning. It has a bite at the margin. It's important. The one thing I would say about Carlos's structural argument, I just wanted to note, is that that's at some point, you know, what we try to do is look at specific constitutional powers and maybe how they relate to the background law of nations and how they interact, and maybe how the law of nations even shape the power and vice versa, right? Maybe the power incorporates the law of nations, or maybe the law of nations shaped the power and how it was assigned. I think when you get to a higher level of abstraction where you're saying any state violation of customary international law today implicates the nation as a whole, that's certainly true. This kind of goes back to Pierce's question. It's not really clear, though, how you conclude necessarily that that authorizes courts to invalidate the state practice. And it's true that federal lawmaking is difficult, but it's also true that Congress has to act to correct state problems all the time. And that's one of the things, you know, that's why the Congress has the commerce power and its other enumerated powers, was to give the federal authority the ability to rein in states when it was necessary for the nation as a whole. So I don't think we can have a totally dormant, structural argument, which is courts can step in whenever states get out of line, because that has the ability to maybe, make Congress less relevant. But I understand the argument.
We've hit the we've hit the 1 hour mark, so maybe I
Can I
can
respond to
I'll ask Carlos to respond on Al-Bahani, and also on the suggestion that maybe this is a debate that's not all that
Right.
meaningful in practice.
Well,
and then we're going to wrap up,
well,
and folks can stay and visit if they want.
on Al-Bahani, I don't have any dispute with what Kurt has said, and I think I will agree with Kurt that his position is not completely grudging, and among other things, he accepts the Charming Betsy canon, which is here under number 7, and that, I think, is what is relevant to Al-Bahani. It's a statute, an ambiguous statute, and we construe it in conformity with international law if possible. He's not opposed to that, and of course I'm not, but the more general point is, it ties into Kurt's next point, which is that the debate doesn't matter much. It matters perhaps less now that we have a lot more federal statutes. And so we have a lot of federal statutes, and if we construe all of them consistently with international law, we've taken care of a lot of the problem. Have we taken care of the whole problem? It's interesting to hear Kurt say that there's nothing much turns on this, because I've just spent a lot of time writing a 135-page article on it. But it seems to be odd for him to be saying it, because, as he noted, he's written a lot more on it. He spent a lot more of his time making this point, and in fact initiated the revisionist approach. So it's odd to say now that it doesn't much matter. And if it in fact doesn't much matter, it doesn't much matter either way, right? I mean, what much would turn on accepting my position? And yet you seem not to be willing to do so. So maybe, and that gets me to the one specific example that Kurt mentioned, the juvenile death penalty, maybe a case like that. But Kurt himself has written that the juvenile death penalty doesn't violate international law. I think that before the Supreme Court decided that it violated our 8th Amendment, at least even to the extent that international law generally would have invalidated the juvenile death penalty, the United States would probably have been a persistent objector and not bound by that. So I don't view that as an example of a situation where customary international law would have required invalidating those particular penalties. If there aren't more examples today, I think it is largely because of the prevalence of the traditional rule that states don't have the power to violate international law. If they haven't thought they had the power, they would try to avoid it. And so that leads me to the conclusion that the problem is possibly more in the future. And now is when we have states saying explicitly, we're not going to comply with customary international law. We're going to, our courts cannot refer to it, cannot enforce it. And so I worry that if the revisionist view is correct, they will be allowed to do that. And so who knows what might come of that. So I'll leave it at that.
Okay, well, thank you very much. Thank you all for coming. I think our speakers will be willing to hang around and discuss a little bit more with you if you'd like. If this has whetted your appetite, there's a lot more coming at the ASIL annual meeting in a couple of weeks. There will be a session on Kyoto. There will be a session on the U.S. approach to treaties. There will be a session on Jeremy Waldron's new book about foreign law in U.S. courts. And a lot more of this ilk. So hope that you all can come and also participate in more sessions here at Tiller House. But thanks to our speakers.